If you have been charged with domestic violence, it can seem really scary. I mean, you have literally the government with all of its power against you, right? But in this video, I'm going to be talking about a key weakness in how the prosecution prepares domestic violence trials. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to win your restraining order hearing. So if that is an issue you are facing, planning to represent yourself, you can get your free first class in the course via the link down below. Okay, the key weakness in the way that the prosecution prepares for domestic violence trials in the state of California. The number one rule of testifying, and this would apply to any witness, whether it's in a restraining order hearing or in a trial, the number one rule is to review all of your previous statements because you don't want to get caught in an inconsistency. I mean, getting caught changing your story is the classic way to seem like a liar, right? If you are telling the truth, if you are thinking back to a memory of something that really happened and describing it, you might forget some details, but when you are describing key details, important things, you are not going to change your story. But if you're lying, if you're making it up, then you might forget. So for domestic violence cases where there's probably a lot of communications with the other party, you want to read your communications, your texts, emails, whatever, sort of like a book. So if you are a criminal defendant or you're testifying in a restraining order hearing, these are all things that you should be doing. You want to make sure that you do not get surprised. You don't forget that you wrote something or said something a while ago. You have reviewed it all. Even if you're telling the truth, you don't want to get anything wrong or change it. But here is the big blind spot in how the prosecution prepares for domestic violence trials. Usually, they do not prepare the alleged victim very much. They subpoena them, they stick them up there on the stand, and they either trust or expect that if they are telling the truth, then there won't be any problems. Look, prosecutors are busy. They don't usually have time to track down alleged victims and prepare them for a while. They might interview them, they might call them, but usually they're just going to talk to them at court. Sometimes they will show them the police report, but the alleged victim didn't write the police report. It may or may not actually accurately describe what the alleged victim said, so that can actually potentially mess them up. They typically do not show them body-worn video of exactly what they said to police officers or a transcript of it. They don't usually make time for the alleged victim to provide their documents, text messages, anything like that. They are not going to look through all of the text messages between the defendant and the alleged victim. They don't have time for it, and it's just not how they work. If there is a restraining order, by the time you get to a trial in a criminal case, you are probably 6 months to a year from the arrest, at least. So if the alleged victim filed a request for a domestic violence restraining order, then that hearing has probably already happened. So there may be a transcript of that hearing. These DVROs, these domestic violence restraining orders, they are not in criminal court. To get a transcript, it's not always easy. In a lot of counties, you have to first try to figure out who the court reporter was, which entails making phone calls to the clerk. A lot of times the prosecutors do not get that DVRO transcript. And they often won't even look at the application for a domestic violence restraining order that the alleged victim wrote. So if there is a restraining order, the alleged victim had to describe events that probably have to do with the arrest. They are probably explaining the exact same situation that caused you to be arrested. And many times, if you look at what the alleged victim says in the restraining order application and you compare it to what was said on the body-worn video, there are going to be big differences there. This is a huge blind spot that the prosecution has. So as the defense, obviously, you want to get all of these things and have them all ready. Typically, if I'm going to a domestic violence trial and the alleged victim is not on our side, then I'm going to have not only a transcript of what they said, but I'm going to have it linked to exactly when they said it in the video so I can quickly pull it up and play it and show that they changed their story. What about the 911 call? If the alleged victim called 911, usually the prosecution is not going to give a copy of the 911 call or transcript or even play it for the alleged victim. And again, when you get a transcript of that, often some of the details are going to be significantly different than what the alleged victim told police and or what the alleged victim wrote in a restraining order application, if there is one. Now, one question you might be wondering is, okay, but if you as the defense attorney, if you get a copy of the DVRO transcript, do you have to give that to the other side? I mean, that might have statements from the defendant in it too, right? You might not want to give it over. So the answer to that is that you do not have to. You order it, you put it in your file. If the alleged victim changes their story, then you can pull it out and you can use it against them. But you don't have to give the whole thing to the prosecutor, and you don't have to notify the prosecutor in advance that you have it, because this is impeachment evidence. You also don't have to give them your transcript. And look, if the alleged victim is against you, maybe reluctantly, this is the way that you win a domestic violence trial, by emphasizing that these are big changes, whatever they are, that somebody who, if they are telling the truth, they would surely remember and they would surely get right. When you start catching the alleged victim in a whole bunch of lies, if you look over at the prosecutor, unless he or she has a really good poker face, you can see them just sort of giving up. I mean, I've seen prosecutors sort of put their head in their hands. You see them looking down. They won't make eye contact. You know, it's sort of like, well, this is no reflection on me. I'm a great prosecutor. But unfortunately, our alleged victim here was either lying or is just a horrible witness. And you will see that for the rest of the case, whatever else is happening, usually their fire has died down significantly. Sometimes, if you roast the victim enough on the stand, if you catch the alleged victim in enough lies, you can get them to come to the table and actually dismiss it without even waiting for the jury's verdict. I hope you found this video helpful. If you do have a domestic violence case that you need help with, you can find my number down below. You can also find a link there where you can book a consultation. And if you're facing a restraining order hearing, remember, get your free first class in the description box down below on how to win that hearing while representing yourself. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.